for Charles Manson? Or will it? Joining us right now to talk about the Charles Manson parole hearing is Charles Manson's attorney, Dejan R. Lewis. Mr. Lewis, first of all, thank you for joining us here tonight on the Tate LaBianca radio program on StarCityRadio.com. We much appreciate it.
No problem.
If you would, Mr. Lewis, start with a little backstory on how you came to be Charles Manson's attorney for this parole hearing.
Well, it was kind of luck of the draw, to tell you the truth. I do a lot of state-appointed work for the Board of Parole Hearings, the California Board of Parole Hearings. I do lifer hearings for them every other month or so, a week or two out of every other month. And when they assign me to work at whatever prison that I choose or whatever one I'm working at that particular time, they give me the whole week of those inmates who can't afford their own attorney. So I'm assigned the entire week of parole consideration hearings, whether it's Joe Blow or Charles Manson. And this particular week, I ended up with Mr. Manson, and I went to go interview him last month in preparation of the hearing, and he refused to come out of his cell. And so we were hoping and keeping our fingers crossed that he would come out for his hearing, because this, quite frankly, can be his last hearing. He's 77 years old, and with a 15-year denial, which he received on Wednesday, he'll be 92 when he's able to come up to come to the next board hearing.
Did he give an excuse or a statement to you or anybody in there in the prison as to why he didn't want to meet you and why he didn't want to attend his parole hearing?
I was not given any information with regards to why he didn't want to attend or anything like that. All I was told is that the correctional officers were not going to comply with his request as far as any special request that he was making as far as the hearing is concerned. They weren't going to do anything special for him, and I guess when they denied that, he declined to come out. That's all I was told.
So how do you go about preparing to represent an inmate who doesn't cooperate?
I represent these inmates, and I do it in a fashion where, if they are proactive in their recovery and in their rehabilitation, and they show up to the hearing with me, or to the interview rather, and we sit down and we go over what type of programming they've done, and it's discovered that they are suitable by, just me looking at the record and whatnot, I'll tell them, I think they're suitable, let's go forward. If I don't think an inmate is suitable, I'll tell them I don't think they're suitable, and I'll tell them the reasons why and what they need to do to become suitable. In this instance, I wasn't able to even afford the opportunity to do that because he wouldn't come out of his cell. But nonetheless, Mr. Manson, so the record shows, has not engaged in any type of rehabilitation when it comes to, trying to become suitable. He didn't engage in any self-help related program. He never picked up a trade. He didn't go to AA or NA or anything like that. So I would have had to have told him anyway that I didn't think he was suitable and that he should stipulate for unsuitability for a 3-year denial so he could come back in 3 years. But I didn't even get that opportunity to convey that to him. So because he didn't show up at this hearing and because he didn't show up at his interview where we could have tried to sign a stipulation agreeing that he wasn't suitable for 3 years, the board gave him the maximum of 15 years.
We're talking with Charles Manson's attorney, Dejan R. Lewis, on the Tate LaBianca radio program on StarCityRadio.com. Mr. Lewis, this is an email question from one of our listeners, if that's okay. What happens when an inmate doesn't show up for their hearing? Does that expedite the process? Do you have to sit through the hearing anyway?
Well, we held the hearing in absentia, with him in absentia, but, when it comes down to it, they're going to go through the full-blown hearing. They went through all the modalities like normal, but it was, of course, shorter because he wasn't there to either testify or rebut anything that's incorrect in his record or give a statement or speak on his own behalf. So it went relatively quickly as a result.
We know Deborah Tate, Sharon Tate's sister, was there. Were there any other victims' family members attending?
No, just Miss Tate.
Now, where does this leave you, Mr. Lewis, in relation to Charles Manson? Because you are his last attorney of record, correct?
I'm his attorney of record with regards to the last proceeding. But, if he was ever to get another parole consideration hearing, it would be, if he goes by way of state, as a state-appointed attorney, it's going to be the luck of the draw of us panel of a state of attorneys who might get his case. I could get it again, but the odds are pretty much against me on that.
Now, you actually made an objection to the 15-year denial. Can you talk about that for a moment? Because Manson still got the 15 years.
That's the maximum. That's the maximum under Marcy's law here in the state of California, which totally changed the parole denial period from 1, 2, 3, 4, 5-year denials to 3, 5, 7, 10, or 15. Now, there are a couple of cases in higher courts right now that are being litigated that's trying to overturn Marcy's law with respect to those lifers who are seeking parole, because it's looked at as ex post facto, which is a law that's making, that makes activity prior to its enactment illegal, and then treating those whose crimes were enacted before or conducted before the new law, they're treating them just as if they committed their act after the law was enacted, which is unfair. It's ex post facto is the term that we use, and it's illegal and unconstitutional to do so. And in the case of N. Ray Biggs, the courts agreed with that, but of course, the state of California and all the district attorneys in the world, they're going to go after that, and so that's what's happening right now. So with my objection, when I made it, it was overruled because Marcy's law is still the state law here, or the law of the state of California. And so until it's overruled with respect to that minute portion of Marcy's law, parole consideration hearings and those people who were convicted of crimes prior to Marcy's law enactment are still going to fall under that 3, 5, 7, 10, or 15 rule denial.
Another question, Mr. Lewis, if you would, out of our live discussion room from earlier at starcityradio.com/live, is Charles Manson still in the hole? Is Manson still in isolation?
He's not in the administrative segregation unit. He's in the SHU, the segregated housing unit for his own protection. Not only that, but there's some things that have gone down that I'm not going to talk about that he was accused of last year that have, basically put him in a higher secured setting.
And now you believe that Mr. Manson shouldn't be incarcerated, but more hospitalized, correct?
Well, his file does say that he doesn't suffer from an Axis 1 severe mental disorder, which I think is unfortunate because he has been diagnosed with schizophrenia in the past, which is an Axis 1. But now they're saying, no, he suffers from antisocial personality disorder with schizotypal attributes, if you will, which doesn't get him into the state hospital. If he had gotten some mental help, I think earlier on, maybe, they could have helped him to the degree where he might have started programming, 30 years ago. They have done the things necessary that those inmates who are seeking parole do. Those reasonable inmates that are seeking parole, they engage themselves in everything that the California Department of Corrections has to offer so they can be found suitable. And Mr. Manson has never done any of these things, and that just tells me that his mental state, in my opinion, and this is my own personal opinion, is causing him to not get himself to a level of suitability because, I think psychiatrically he doesn't know that he needs that kind of help, And by a person who gets that kind of help goes through what they call mental health awareness courses. And once they learn or come to grips with the fact that they have a severe mental disorder and they take the medication that they need, once they get to a level that they call remission, then they start programming. They know that they have a problem and they start doing things to help themselves. The Manson was never afforded this. And this is why, people like me are out here not to try to get killers out of prison, but to get those who deserve a second chance, deemed suitable for parole.
At least a fair chance.
Yeah, he was never given a fair chance because public outcry was just too horrendous for this case. And, people wanted justice, and they got it in the form of a death penalty. Well, if he got the death penalty, why did they commute his sentence to life with the possibility of parole? It doesn't make any sense to me. You would think that the next level would have been life without possibility, but they gave him the opportunity to have parole. That means to me that you're going to do everything in your power to assist him in getting to that acceptable level of remission so that he can help himself. And the state of California just put him in a hole and let him rot there for the last 30 years. That wasn't fair to him.
So it's fair to say then, Mr. Lewis, your view is that they gave him life with parole technically, but not really because they had no intention of giving him, Mr. Manson, a chance of rehabilitation.
Well, 11 parole hearings You know what I'm saying? 11. And that was state taxpayers' money that was used to conduct those hearings. They had to pay all those attorneys to represent Mr. Manson if they were state appointed. You know, you got to pay all these extra correctional officers for security. You name it. Every time he goes to parole in front of the board, they're going to have all the media in front. You know, just all this manpower, but they never gave him or afforded him the opportunity to try to better himself so he can say, well, yeah, I was messed up back then, but look what I've done since then. I know what I've done is wrong. Well, a person like Mr. Manson, who has what they quote-unquote call, you know, severe personality disorder, antisocial personality disorders, and these types of things, if they're put in a state hospital, like I said earlier, and treated, they may, I say may, not all in all cases, but they may come to grips with what they've done and what treatment they need, so they can get to this acceptable level of remission that they can be treated and go out in the community and be a viable citizen in our community. You know, I mean, I don't think they afforded Mr. Manson a service by giving him life with possibility. That was incorrect. I mean, because this man, if you're going to do that, then help him get to a level of remission that he can be rehabilitated. If you're going to say life without the possibility, then okay, put him in the hole, let him rot there for the rest of his life. And that's what they're doing here. You know, so it's counterintuitive, it's contradictory in terms, and it bothers me.
Bothers you professionally or personally, or both?
Well, I'm going to tell you why it bothers me, because I do parole hearings in a Tascadero State Hospital. If Mr. Manson was ever deemed suitable for parole, the first thing that the chief psychiatrist of the Department of Corrections is going to do is designate him a severe mental disordered offender so he can get mental health treatment while on parole, the 3 years or the 5 years that he would have been on parole. That's what they do with everybody who goes to a Tascadero Penal Code Section 2962. If they committed their crime as a result of the commission of the crime was enacted as a result or contributing factor due to a mental disorder, they're going to send you to the hospital. You're not going to be paroled immediately. And so I know if he had ever been paroled, that's what would have happened, and I could have very well ended up representing him there at the Tascadero. So looking at it from that perspective, they're sending these guys to the state hospital to get treatment so they can get to a level of remission that once they are put on the street, they don't commit any more crime. Well, what's the difference here? You know, this man was given possibility of parole, but they never did anything to assist him in getting there. You know what I mean? Department of Corrections and Rehabilitation. Well, there has not been any corrections in Mr. Manson's state, and there's definitely no rehabilitation. So that's where they failed him. I believe the California Department of Corrections, even though Mr. Manson is charged and has been convicted with one of the most heinous crimes in United States history, and definitely in California history, you know, I understand that, and I make no qualms about it. He deserved to go to prison. However, once they put him in the classification of possibility of parole, okay, well, then you need to afford him these services.
What about those that would argue that Mr. Manson has been offered the medication and the programs over the years, Mr. Lewis, but he's chosen not to take them?
Well, they give forced medication people all the time. It's called a CAHIA. They have a CAHIA hearing, and they force medication on these guys all the time in the prison system. Why that wasn't done here, I don't know. Maybe they could have got him to a level of remission. Or maybe I'm wrong. Maybe these doctors who have diagnosed him recently, who say he has a severe personality disorder, maybe they're right, and then maybe medication might not have helped. But I think putting him in the hospital and getting a diagnosis by those psychiatrists that work there, maybe that would have gone a long way. At least put him there for a time being to evaluate him. I don't even think he was properly evaluated.
Well, and you may very well be right, Mr. Lewis.
One last thing, Commissioner Peck, and I know him well, I've worked with him on many occasions, he did say that if Mr. Manson decided to start programming, if he jumped into AANA like today and took some victim awareness courses and anger management and the things that the board looked for, I don't think they'll want him to have a trade at this point at 77. But if he did these things and remained disciplinary-free for the next 5 years or so, I think there's a form that you can file requesting an earlier and expedited hearing because things have changed. You know, you can file that document and ask for another hearing, and if the board believes that he has done these things that he proclaimed, then they will give him another hearing. That's his best bet.